Hello, welcome to Timmy Matt Law with me, Mr. McClellan. For this video, we are going to be discussing a breach of duty and looking in particular at risk factors. And just to re-emphasise the context in which we are covering all of this content, we are analysing liability for physical injury and damage to property under the tort of negligence. And a person is thought to be negligent if they have done something which they really ought not to have done, or they have failed to do something which they really ought to have. Now, in order to determine liability under the tort of negligence for physical injury and or damage to property, you need to instinctively remember this 3 bullet pointed equation. Let's take the first bullet point. The defendant owes the claimant a duty of care. Second bullet point, the defendant breaches their duty to the claimant. Third bullet point, the breach by the defendant causes damage to the claimant. Now, in order to establish the first bullet point, does the defendant owe the duty of care to the claimant, you would apply the neighbour principle and the more stringent Caparo 3-part test, which we've already covered in previous videos. Now, second bullet point, the defendant breaches their duty to the claimant. Here you'd bring in the concept of the reasonable man and the 4 different types of reasonable man that exist. Again, we've covered that in a previous video. All of this content here on risk factors we're going to place essentially up here because you will consider the different types of reasonable man in hand, side by side with the different risk factors that exist. So they will go up here. And then final bullet point, the breach by the defendant causes damage to the claimant. That relates to the issue of causation. You will understand the principle of causation, but it does work very differently in the tort context as opposed to the criminal context. So just be mindful of that. And of course, we will focus on that in time. Now, let's focus on these risk factors in relation to the defendant breaches their duty of care to the claimant. And if you consider that the defendant has breached their duty of care to the claimant, well, the next inquiry that you must explore is what standard of care is required. What is the expectation of the defendant insofar as their behaviour and conduct towards the claimant? How could you accuse a defendant of breaching their standard of care if a standard does indeed relate to the duty of care that should exist if you are not sure of what standard you expect of the defendant? So therefore you've got to be clear as to what standard you expect of the defendant and have they met it or not. Now, the particular circumstances of a situation may raise or lower the expected standard of care. And that idea also relates to the different types of reasonable man. The detail, the context of a situation through which the claimant is making a claim determines whether the standard of care expected of the defendant is raised or lowered. Sounds awfully complicated. It really isn't. Now, when it comes to these different types of risk factors, which we'll get to, they beg the question, would the reasonable man take more or fewer risks given these particular circumstances, these particular details and nuances of a situation? There are 5 different types of risk factor. They are fairly straightforward, common sense questions that you'll automatically almost have in your mind when you're analysing a situation. So, without further ado, let's crack on with the first risk factor. Number 1, are there any special characteristics of the claimant? And this relates to any particular characteristics or vulnerabilities that a claimant may have which should probably raise the standard of care expected of the defendant. So, if the defendant knows that the claimant is more vulnerable, then an increased standard of care is expected of them, as shown by the case of Paris versus Stepney Borough Council 1951, Stepney being a place in London. Now, in this particular case, you had the claimant who was blinded in one eye but had a perfectly operational and working eye, and therefore their sight was through that one healthy eye. Unfortunately, they got a metal splinter when working as a garage hand in that eye, and therefore they took Stepney Borough Council to court, making the claim that they should have been provided with protective goggles, particularly because of their special characteristics in only having one functioning eye. Now, the defendant argued that they didn't provide protective or indeed specialist equipment to any of their workers when it came to eye protection. The claimant argued that they should have done For him, because he only had one functioning eye, and therefore if he was blinded in that one functioning eye, he would be rendered blind. A much more serious consequence had a similar situation happened to one of the other workers, presumably because they had two functioning eyes. And actually the claimant succeeded in their claim. There was a higher standard of care, and indeed the defendant should have given protective goggles to the claimant because they only had one functioning eye. The consequences for damaging that eye were much more grave than a so-called normal person who would have had two functioning eyes. So the claim succeeded, okay? Higher standard of care expected of the defendant in that particular case. Next risk factor. What is the size of the risk? The reasonable man takes more precautions where the risk is greater, but does not take precautions against highly unlikely events. And really this relates to what is practical given the circumstances. Very little in life can be made completely safe. Okay, and I think this principle really takes this into account. Let's look at the cases. Bolton versus Stone, 1951. Here you had the claimant who had been hit by a cricket ball, which was hit by the batsman 100 yards, which then caused the cricket ball to hit the head of the claimant, causing injury. Now, the claimant argued that the cricket club should have taken more precautions to prevent the cricket ball from flying in her direction. Now, the cricket club argued that they had erected already a 10-foot fence, and also the wicket from which the batsman had hit the ball was sunk 7 feet below the start of the fence. So effectively there was a distance of 17 feet between the batsman, the 7 feet up to the beginnings of the fence, and then the further 10 feet to the top of the fence. And also it was a distance of 100 yards. It was quite an exceptional strike by the batsman, and indeed neighbours did argue that they'd only seen a ball leave the cricket ground 5 or 6 times in the past 30 years. Had the cricket club done enough in taking all practical precautions given the size of the risk? Well, it was considered to be a highly unlikely event whereby a cricket ball would leave the ground, and therefore it wasn't becoming of the cricket club to erect an even higher fence to protect passers-by, and therefore the claimant's claim failed. Okay, the cricket club had done all they needed to do to protect members of the public against any potential risk, but they didn't have to necessarily guard against highly unlikely occurrences of a cricket ball being hit 100 yards and going over effectively a 17-foot high fence. Now, next case example, Haley versus London Electricity Board, 1965. And this is where you had two workmen who had dug an open trench and they went for lunch. And they, in going for lunch, placed a pick at one end of the trench and also a shovel and also a punner, which I do believe is some sort of hammer which you kind of hammer down tarmac. It's a relatively simple object, but it does have quite a long handle. And indeed, a claimant tripped over the handle when the workmen were going for lunch. Now, it was argued by the claimant, who happened to be blind, that a higher duty of care, higher standard of care should have been shown towards passers-by, not least who could have been blind people. And therefore, the workmen, the defendants, really should have fenced off the open trench. They shouldn't have left it simply by marking out the trench with their tools. And indeed, the court agreed with the claimant. A higher standard of care was expected of the defendants because it was perfectly plausible that a blind person could fall into that trench and suffer injury if it wasn't warned off, fenced off accordingly. And indeed, rather tragically, the blind man then became deaf because of the injuries that they suffered. Okay, so it was a plausible risk that could have occurred, and therefore the defendant really should have done better in terms of fulfilling their standard of care to the claimant. So hopefully that is fairly understandable material. I think it probably is. Next risk factor: have all practical precautions taken or been taken? And I think this relates very closely to what is the size of the risk. We talk about practical precautions. Have all practical precautions been taken? There has to be a balance between the risk involved and the cost and effort of taking precautions. Nothing can be made 100% safe, and if indeed you're going to get close to something being completely safe, you're probably going to be spending a lot of money and a lot of time in doing that. And is that really practical given the circumstances which people face in everyday life. Let's look at the case example of Latimer versus AEC Limited, 1953, and this is where you had a company, AEC Limited, who had suffered a flood in their factory because of adverse weather conditions. They mopped up the flood, they put sawdust down and warning signs to stop any slippages, and yet the claimant actually slipped on the floor of the factory, therefore forming the basis of their claim. They argued that the factory owner should have done more to prevent the risk of injury through a slippage. However, all practical precautions were taken. It was ruled by the court. It wasn't expected that AEC Limited should have done anything more. I guess the question should have been, should they have closed the factory? But the judge argued that they didn't necessarily have to do that. They'd done the warning signs, they'd done the mopping up, they'd done the sawdust, and that was sufficient insofar as satisfying the taking of practical precautions and them meeting the standard of care that was expected of them. Fourth risk factor. Is the risk unknown? There is no breach of duty if the risk of harm is unknown. There are some injuries, some forms of harm that can take place, and there's no way you could foresee it, and therefore, if that's the case, there is no liability on the defendant. And this relates to the tragic case of Rowe versus Minister of Health, 1954, where you had two patients and they were operated on in relatively minor operations, and yet they became paralysed. Now, investigating their deaths, it was realised that the anaesthetic given to the two patients had actually been contaminated with sterile fluid. Now, it was discovered that the anaesthetic was stored in glass vials which had actually suffered from hairline cracks which were not visible to the naked eye, and therefore the defendants couldn't know about it. Now, the anaesthetic, the vials, were stored in the normal way, normal procedures. However, the sterilising substance which surrounded them leaked into the anaesthetic. The anaesthetic was then given to the claimant, and therefore they were paralysed. But there was no way of knowing of that particular risk, given that the cracks in the vials weren't noticeable, and it was a normal way of storing the anaesthetic for patients, and therefore the defendant had not breached their duty of care to the claimant, so therefore the claim failed. Rather tragic set of circumstances there. Now, the final risk factors. What are the benefits of taking the risk? There is a lower standard of care when reacting to an emergency. Now, think about that. You've got an emergency situation, and by that we are talking about a question of life or death, and therefore should a higher standard of care be expected of those people who are rushing in a rather panic-like fashion in order to save someone's life, or should the standard of care be lowered? And I think you already know the answer to that. The standard of care should probably be lower given the circumstances of reacting to an emergency. And let's look at these case examples. We've got Watt versus Hertfordshire County Council, Hertfordshire in the southeast of England, 1954. This is where you had a road traffic accident whereby a lady was stuck under a lorry. The fire service turned up to the scene looking to rescue the lady, but they needed a jack and a piece of equipment to jack up the lorry to remove the lady from under the lorry. Now, the fire service's own lorry, pickup truck if you like, which was needed to take the jack from the fire station to the larger lorry, which was on top of the lady, wasn't available. And therefore, the fire service chief requested that some of the fire men, or indeed women, I guess, although the case was 1954, so I imagine it was mainly men in those days, the firemen to actually go and pick up the jack and carry it onto a vehicle, hold it in place to take to the woman to rescue her. Unfortunately, there was no protective equipment holding the jack in place, and it slipped, injuring one of the firemen's knees. And therefore, that was the basis of the claim for the firemen, but the claim failed simply because they were reacting to an emergency in ordinary, calmer circumstances, as it were. Then the jack would never have been requested to actually go and help this lady. But it was an emergency. The lady had to receive the help of the jack in jacking up the lorry, and therefore it was a case of getting the jack very quickly to the emergency scene, and therefore the fireman was required to essentially hold it in place, okay, thereby causing the injury. But quite a low standard of care expected given that emergency situation. And then the final case we've got here is Day versus High Performance Sports, relatively modern, 2003. This is where you had a climber who had failed to tie their climbing rope effectively to themselves and also to the person on the ground who was holding onto their rope, and indeed they were kind of left in an emergency situation, stranded in midair. Now, the defendant went to go and rescue the particular the claimant, and actually they made a bit of a bodge of it, and therefore the claimant fell and actually suffered an injury because of the fall. Now, in hindsight, it was considered that a different rescue operation could have been mounted to save the climber. That said, because it was an emergency, and indeed the defendant didn't have much time to consider their options, they took the best course of action at the time. It didn't work. The claimant actually suffered injury, but they did their best. They weren't negligent. They had misjudged the situation, but they hadn't been negligent in the situation. And actually, they had taken all practical precautions in training their staff and actually getting the climbers to sign a bit of a disclaimer, it seems, to say, look, we will protect ourselves when climbing this wall. We know what we are doing. Fortunately, that didn't seem to be the case, and indeed the defendant, in trying to help, made a bit of a bodge of the job, but they weren't negligent. They just could have done better with the benefit of hindsight. But in an emergency, of course, you don't have the benefit of hindsight, so claim did not succeed. Final kind of aspect that I just want to re-emphasize to you, and I mentioned it at the start of the video, when you consider the breach of duty, take hand in hand the 4 different types of reasonable man together with your 5 risk factors. You bring them all into play, and normally they will come to the forefront of your mind on automatic. Okay, so lots of stuff to remember, yeah, but with greater practice, this is really kind of common sense questions that you'll be asking anyway when you analyse a scenario. Hope that was useful for you. Thank you very much.